The last segment I talked about interposition, also known as nullification, as a viable remedy for federal overreach. Today I want to talk about a last resort remedy, secession. First, we need to answer the question, is secession allowed by the Constitution or something else? There were plenty of debates before the Civil War about this question. Not so many since then, until recently when many of the states are getting fed up with the federal overreach. I will cover both sides of the argument. Those who say that secession is not legal lean heavily on Lincoln's speeches and actions and the writings of Justice Joseph Story, Chief Justice John Marshall, and Daniel Webster, who was a great orator and a Secretary of State and a senator. Their arguments can be condensed into the following. We have a perpetual union. These words are taken from the title of the Articles of Confederation. Because it is perpetual, it is indissoluble. In other words, it can't be broken. The perpetual union continued under the Constitution because we formed a more perfect union. Another argument is that the union was formed by we the people, as stated in the preamble, meaning the people of the United States as a whole formed the union. The United States was made up of one people, and therefore a state had no right to change the government that was created by the whole people. This argument was first espoused by Joseph Story, who said the United Colonies must be considered a nation de facto. The Continental Congress to Story represented a general national government that was organized with the consent of the sovereign people taken in the aggregate. Another claim against secession is that the constitutional basis of secession has been resolved by the Civil War. This argument was stated by Supreme Court Justice Scalia. Another argument is there is no right to secede, as the Pledge of Allegiance clearly illustrates through the line, one nation, indivisible, also stated by Scalia. In the case of Texas versus White in 1869, Supreme Court Chief Justice Salmon P. Chase wrote that, quote, the union between Texas and the other states was as complete, as perpetual, and as indissoluble as the union between the original states. Another argument against secession centers on the language of Article 1, Section 10, which declares that no state shall enter any treaty, alliance, or confederation. Two proponents of this position, Article 1, Section 10, unequivocally shows that the states which formed the Confederate States of America were in clear violation of the Constitution, thus invalidating their government and the individual acts of secession which led to it. Abraham Lincoln indirectly defended this position by declaring the seceding states were in rebellion and therefore still members of the Union. One modern argument says that the 14th Amendment has settled the matter. They say the text of the amendment is explicit that anyone born in the United States is first a United States citizen and then a citizen of the state they are in. Therefore, the state cannot deny a person of his U.S. citizenship by secession. Unfortunately, the 14th Amendment was clearly not intended to address the issue of secession, and that amendment has been used to justify many progressive ideas that it was not intended to address. There are other minor arguments, but these are the main ones that deny the legality of secession. All these arguments can be easily refuted. Since I agree with those who say secession is valid, I'll spend most of my time showing that it is valid. The main antebellum figures who advocated that secession was constitutional were John C. Calhoun and St. George Tucker, who was a lawyer, law professor, and a judge in Virginia. The main arguments center around the sovereignty of the states and the compact between the states and the national government. The Constitution was a compact between the sovereign states, therefore a state had the authority to separate from the Union, that is, withdraw from the compact. This idea is shown in many of the documents of the day. I've already discussed this idea of a compact in a previous lecture and have shown that it was the majority opinion and the accepted view of the founding era. To summarize the argument, Jefferson said in 1826, The Constitution of the United States is a compact of independent nations subject to the rules acknowledged in similar cases. The other arguments against secession can be easily refuted as well. The term perpetual union didn't mean forever, as is commonly used today, but just that it had no built-in sunset provision. Many compacts of the day called themselves perpetual even though they were eventually dissolved. Therefore, it didn't mean indissoluble. Just like a marriage is supposed to be perpetual, although everyone knows it could end in divorce. The Pledge of Allegiance analogy is the most absurd argument of the bunch. The modern pledge was written by Francis Bellamy, a socialist minister who wanted to indoctrinate American school children with a nationalistic message, one based on the great speeches of Daniel Webster and Abraham Lincoln in relation to the one nation which the Civil War was fought to prove. The founding generation would not have said such a pledge, if for no other reason that most did not view the United States as a nation in the strict sense of the word, a single people. Before the Civil War, most people such as Robert E. Lee considered their state to be their country. He turned down Lincoln when offered the head of the Union Army, saying, "How could I fight against my country?" meaning Virginia. The United States was a plural noun before the Civil War. After it became a singular noun. The idea that the secession debate was settled by the Civil War is also false. If true, it would mean that might makes right, regardless of law. The secession debate ultimately boils down to whether the Constitution is a compact of the states or the result of the will of one united people. The compact between the states is the stronger argument, what the founders intended, and therefore the correct view. But what does the Constitution say on the matter? Absolutely nothing. That is why the debate still rages on. There is nothing in the Constitution about how a state can go about leaving the Union. However, neither is there anything in the Constitution saying that a state cannot leave the Union. Therefore, as per the 10th Amendment, the federal government has no authority on the matter, and therefore the decision is left to the individual state. To assert that the states lack the power to secede is to ignore the 10th Amendment itself. A very dangerous move, but a common one today. Unfortunately, the arguments for secession are usually associated with the Confederate States and slavery, even though one of its major advocates, St. George Tucker, wrote a plan for the gradual abolition of slavery. As a result, proponents of secession are usually discounted today as racist. The South was legally correct that they could leave the Union, although they were morally wrong concerning the issue of slavery. As a matter of fact, it was the New England states that first talked of secession. They called it disunion instead of secession, but the sentiment was the same. Those states met in convention at Hartford, Connecticut in 1814 and drew up a list of grievances against the federal government in what they called Madison's War with Britain, the War of 1812. If their demands weren't met, there was an implied threat to secede. At the convention, Gouverneur Morris, who at the Federal Convention of 1787 had written the final draft of the Constitution, now argued that freedom was more important than union and advocated the creation of a New England Confederacy. Interestingly, when those demands were going to be presented to Congress, news of the peace treaty with Britain had just arrived, making their arguments and demands moot. So the representatives of that Hartford Convention never even gave the demands to Congress. Bottom line is, secession is a legitimate option for the states. Obviously, this should be a last resort option. However, in today's environment where the divide between political philosophies is getting larger, where our Constitution has been virtually ignored, and where the tyranny of the federal government is becoming more and more oppressive, we may be heading towards secession or something like it. Regardless of what you believe about the legality of secession, one thing is for certain. Our founding document, the Declaration of Independence, acknowledges our right to abolish our government when it is not working. It says, that whenever any form of government becomes destructive of these ends, it is the right of the people to alter or to abolish it, and to institute new government, laying its foundation on such principles and organizing its powers in such form as to them shall seem most likely to affect their safety and happiness. That's our true fallback position.